Thank you for attending the estate planning presentation today, sponsored by Legal Aid Services of Oregon Senior Law Project. Our presenter today is Darren Dooley. Darren is a partner at I'm going to butcher this, I'm sorry, Danius Huglen Cooper, LLC.
Danius Huglen Cooper, yeah.
Sorry. Okay.
That's all right.
I meant to ask you about that. Where he practices in the areas of estate planning, elder law, Medicaid, special needs planning, probate, trust administration, and estate tax planning. He was the chair of the OSB Elder Law section in 2019 and speaks regularly to community groups, presents at conferences, and writes articles for the Elder Law section newsletter. Darren has also been a longtime volunteer with Legal Aid. We appreciate you sharing your knowledge, information, and time with us today. So welcome, Darren.
Thank you, Tiffany. So I'm just going to jump in. There was a question about handouts. You will be receiving those, but I'm not going to be specifically going through each document. I'm going to be talking about them to you as attorneys, things you might want to consider when you're working with clients on their estate planning. And without further ado, I'm going to just start, basic estate planning. There's two equally important but separate periods of time we're talking about when we're dealing with estate planning. The first is the present. Now, planning for incapacity. So we're talking about powers of attorney, advance directives for healthcare, et cetera. And the second time period is after death, planning for what happens with assets, wills versus trust, probate, all the fun stuff. So I'm going to start with powers of attorney for finances. You probably already know that in Oregon, by default, power of attorney is durable, meaning it remains effective when the principal has been deemed to lack capacity, either by a court or maybe a doctor's letter, something like that. And when you think about it, that's when you want to have the power of attorney the most, because if we don't have a power of attorney at that point, when the principal lacks capacity, or we may be in a situation where we have to go to court and get a guardianship and or a conservatorship established for the individual. So in the handouts, there is a generic power of attorney form. Just by the way, it's not the form I use, but being an elder law attorney, I throw a lot of things in a lot of my power of attorney documents that you might not want to have. Things that might be viewed as self-dealing by the agent that I just have to have my agent be able to do when we're looking at Medicaid long-term care planning. Okay, so the power of attorney in the packet is generic for the most part. What I'm going to say to you as attorneys when you're talking about powers of attorney with your clients is that as a practical matter, we never just want to name an agent. We always want to have an agent and then at least one, if not more, alternates. Because I certainly want my estate planning documents to have as long a shelf life as possible. And if I only name one agent and something unfortunate happens to that agent, we're back to square one. We don't have a power of attorney document. Naming an agent, I always get asked, well, can I name co-agents? The answer is yes, but I try to talk my clients out of naming co-agents because banks in particular don't like to see that. Banks are afraid of liability with POAs, and by the way, they don't have to accept them. So I don't want to give a banker an excuse to not honor a power of attorney. So naming a primary agent and then having successor agents is, in my opinion, the way to go. Also, along those lines, when you're naming the agent in the document, I would recommend using the name as it appears on photo ID. Because, in Oregon, for example, generally, DMV forces you to spell out your middle name. And if I put, Darren J. Dooley as the agent on a document, and I show up at Wells Fargo and my driver's license says Darren James Dooley, I have had anecdotally clients come back and say they didn't like that. They gave us a runaround. So I just put the name down as it appears on photo ID for the agents. And then as far as powers of attorney go, some clients ask about, security. How do I protect myself? In Oregon, since about 2012, we do have a springing power of attorney. It's valid. It becomes effective not when it's signed, but upon some event or occurrence, generally incapacity. I'm not a big fan of those for a couple of reasons. First, if the principal is concerned about the agent doing something they ought not to, maybe they shouldn't be naming that person as an agent. Okay, that's a conversation to have. But also, for a springing power of attorney, the trigger event, lack of capacity, we're looking for either court intervention, which we're trying to avoid by planning ahead, or getting a doctor's letter, and some doctors are reluctant to write that type of letter because of privacy concerns, HIPAA concerns. So I'm not a big fan of springing powers of attorney, but they're out there. And if that's the only document your client is willing to sign, well, then you've done your best. But I'm generally a fan of the typical durable power of attorney for finances that becomes effective the minute it's signed. And when I'm out giving talks to the community, et cetera, I always say, if you don't take away anything else from this talk, the one most important document for you to have is a good durable power of attorney for finances. Okay, and I'm going to let that soak in. When you're working with clients, if you can't get anything else in place, the power of attorney, and I tell my clients when I'm signing with them, I sincerely hope you never need this document, but it's kind of like car insurance. If you need it and don't have it, you're in a world of hurt, because at that point it's likely too late to get one. Okay, which leads me to capacity. And capacity is an issue in any estate planning document you're helping a client to execute. But as far as capacity issues go, the capacity to execute a power of attorney is the highest level of capacity as compared to the capacity to execute a will or trust, testamentary capacity, which is the lowest level of capacity. And so based on the nature of my practice, I'm out on the fringe a lot. I do go to hospitals, care facilities, meeting with someone who has a diagnosis of dementia or otherwise, or maybe they've suffered a traumatic brain injury. And so I'm assessing capacity right then. And, for the durable power of attorney, the principal needs to understand the effect of the act they're taking by signing the power of attorney. They're giving their agent authority to help manage their financial matters, assets, retirement accounts, real property. And again, that depends on what's in your power of attorney document. But, do you understand the authority you're giving to this person? Do you think that is a good idea right now? And if I'm getting yes and affirmation, just because someone has a diagnosis of Alzheimer's, for example, does not mean they lack financial capacity does not mean they can't sign a POA. Anyway, hopefully you're never in that extreme situation, but you do need to be assessing capacity. All right. All right. So I'm going to move on then to advanced directives for healthcare, because we have a new form and I want to talk about that a little bit more. I also should mention that if you have questions, feel free to jump in either on the under chat or, turn off your mute and just ask the question. But I'm moving on from powers of attorney right now. And so turning to advanced directives for healthcare. As of September 25th, we have a new advanced directive form. And this comes out of Senate Bill 199. You can go online and look it up. You want to look at the enrolled bill, because that's, they're, the submitted and blah, blah, blah. The enrolled bill is the effective bill. And that should answer a lot of your questions. One of the questions I've gotten since the bill was passed and, September 25th and beyond is, well, do we have to use that form? Because I can tell you this new form is a bit more touchy-feely than the old forms, old versions. And I understand some practitioners might not be comfortable getting out into the weeds with their clients about what their values and faiths and beliefs are. And that's fine, but in the bill itself, it says that the advanced directive form must be substantially the following form. So can you tweak the form? I believe you can, just like in past forms, but substantially the following form, substantially means, in my mind at least, this is the form you need to be using. Because, for example, the previous form that became effective in, I believe, 2019 is significantly different than this form. And so I do not believe you can use that 2019 form. Now, for your clients, if they've signed a previous advanced directive, no matter what iteration, you can reassure them that it has not been revoked by Senate Bill 199. It's still effective. It's just from September 25th of this year going forward, you, in my opinion, should be using this new form. Okay. So also, by the way, the committee, the standing committee that developed this form is still in effect. I believe they're still working on a user's guide. The three attorneys that are on that committee, Stephanie Carter, Christopher Hamilton, and Mike Schmidt, all wonderful attorneys. I'm sure they would be happy to answer questions as well. But there's some things to note in the new form. We still have 3 of the 4, by definition, hopeless scenarios that you're walking your client through. We still have a terminal illness. We still have advanced progressive illness and stages of Alzheimer's or whatever form of dementia and stages of Parkinson's disease. Okay. And we still have permanently unconscious. What they took out is the suffering or pain component because I believe they felt that was too confusing. But we still have those 3 sections, and basically the client, if they choose to, can indicate their wishes about what they want to have happen if they've been diagnosed as being in one of those situations. And you can look at the form in the bill and work that out. We still have the first page is just kind of a summary heads up to the client or the person executing the document. The second page is, the standard, tell us about you, the principal, and then tell us about your healthcare representatives and alternates. And we have name and relationship and address and email address and phone numbers, all that stuff. And then we jump into the directive part. The new form keeps the previous form's option of either signing before two witnesses or signing before a notary public. I think signing before a notary, because generally we're executing these with our clients when we're signing a power of attorney, what have you anyway. Using a notary is simpler. Sometimes it's hard to get two witnesses who qualify as a witness, because you don't want to be using one of the healthcare representatives, et cetera, as a witness. So I'm always notarizing those documents. And then on the back end, after the client has executed the document, you need to have the healthcare representatives basically accept or acknowledge their appointment. That does not have to be simultaneous. It's, in a spousal situation, generally the spouse is the primary healthcare representative. And so the spouse is in the room and we get their signature. But if we're naming family, friends, relatives, children, generally they're not there, and we can get their signature later. Or even at the point of, we're at the bedside, it's a desperate situation, you could sign there. Or the healthcare representative can simply acknowledge verbally their acceptance. They don't actually have to sign the document if it comes to that. So again, their signature was never obtained, and we're in an emergency situation, and the hospital is calling through the list, and they get a phone call and they say, you're named second on the advance directive, but you never signed the document. Do you acknowledge and accept your appointment? Yes. And then they'll start asking them, bring them up to date on what the diagnosis is and the prognosis, and then start asking questions. So that's all very doable. I just never want to have my clients be in that situation. So I encourage them to go ahead and get the alternate signatures on the document and then send it to me, so I can have an electronic copy. One nice thing about the advance directive, for all its faults, is twofold. It's user-friendly in that a copy is as good as the original, which is not the case for a power of attorney for finances. If I'm walking into US Bank to get on my mom's account as her agent, they're going to want to see the original POA. They will not accept a copy. Sometimes you can get around that if you're emailing the POA somewhere, like to the custodian of an IRA, but in general, for the power of attorney, you need the original. Not so with the advance directive. A copy is as good as the original, and on occasion, rare, thankfully, I have emailed a hospital a PDF of an executed advance directive. Okay. One thing about powers of attorney that popped into my mind that I remembered, on execution, the question is, well, does it need to be notarized, the power of attorney? Well, under Oregon law, I see no requirement that a power of attorney be notarized. On the other hand, practicality matters. If you want it to be accepted by a bank in particular, it ought to be notarized, yes. Okay, so the new advance directive, there's, the parts about, information about spiritual beliefs, life's values, place of care. You can also, it's interesting that there is a section that basically is a HIPAA release, which I'm glad that it's there. I am going to talk about HIPAA in a minute, but if you look at HIPAA law, an agent under a power or an advanced directive for healthcare is an authorized agent for HIPAA purposes anyway. But we want to make this as simple as possible for our client, and we don't want them come up against the one custodian of protected healthcare information that doesn't understand that. So there is a release, you can name who healthcare providers can release information to. I'm going to say that under HIPAA law, it really, HIPAA authorization, it needs to be specific. I authorize Meridian Park Hospital to release my medical information to Marina Dooley, that specific. Well, beforehand, a priori, you might not know who's holding the information or who you want to have it. And so I think this section is a good attempt at getting around that issue. I can also tell you that in my power of attorneys, I do, again, based on the nature of my practice, have a broad HIPAA release. I have seen it work. I've also seen it not work. Okay, there's a comment about the POA and the notarization and also having the agent's signature and having that notarized. I have seen, the agent sign, and I've, whether it's notarized or not is up to you. I can just tell you that to get on a bank account, etc., the agent's going to have to go into the bank with the original document and fill out forms and provide photo ID, etc. anyway. So I'm not really sure what that gets you, but if that's your practice, go for it. Whatever you're comfortable with and whatever you're comfortable, working with your clients on, that's fine. Anyway, so the advanced directive form, it's new. I have yet to do a signing appointment using the new form, although I have one on the calendar, so I'm looking at it. I can tell you based on my knowledge of the clients I'm going to be signing with, I probably will not be going too far into the details of those various sections. I will explain that they can fill them out. And again, the advanced directive, very user-friendly. You can write on it after you sign it. I tell my clients, for example, that if they name a child as an alternate healthcare representative and the child goes and moves on them, they don't have to execute a new document. They just cross out the old address, write in the new address. They're still good to go. And so having the client take time to complete those sections about faith and values, beliefs, whatever, that is one option. Okay, I'm going to close my shades just for a minute here. Okay, I'm back. So moving on then, I'm going to talk about POLST and HIPAA release just briefly. First off, when you get the packet of materials, I'm embarrassed. I just noticed that the acronym HIPAA is incorrect in my outline. It's HIPAA is HIPAA, and I just noticed that it's HIPPA. I didn't see that. HIPAA, Health Insurance Portability and Accountability Act, HIPAA, HIPAA. Anyway, the POLST form used to be physicians' orders for life-sustaining treatment. And if you look in the ORSs, I believe it's under 127, that's still the way it's recognized, physicians' orders. But since about 2019, a new form was adopted by the powers that be through OHSU, and they changed it from physician's orders to portable orders. And the reason is because the person who can sign the POLST can be an MD, a DO, a nurse practitioner, a physician's assistant, etc. So all of that, they're not just by definition physician, and so they changed the name. They also changed the form. It used to be a shocking pink form, and I believe because to make it easier to photocopy, it's now just a white form with a pink border. I think everyone, besides having a good durable power of attorney, should have an advance directive for healthcare. Or although I will tell you that if we don't have an advance directive for healthcare, we're not out of luck. Under Oregon law, there's a hierarchy of who can give direction to the doctors of the hospital if we don't have an advance directive, okay? Which is not the case for financial matters, okay? Well, so everyone should probably have an advance directive. Everyone does not need to have a POLST. And I have a couple horror stories where someone incorrectly completed a POLST, basically planning for the future when they were terminal, and saying, you know, basically DNR, do not resuscitate. And they're down in their home or the parking lot of Fred Meyer's, wherever, with a heart attack, and the first responders are made aware of the pulse, and it's DNR, and they're in tears because they know they could have saved that guy. And these are, I'm not making this up, these are true stories. So a POLST is completed in consultation with your primary care physician, I'm going to say, but again, it, you know, MD, DO, nurse practitioner, physician's assistant, what have you, that's fine. When there is a terminal situation, and it doesn't have to be, you know, we're looking at hospice, you know, 6 months or less, but when we have a diagnosis like with cancer, etc., that's when that document is appropriate. And again, I'm not a doctor, I'm just telling you based on my experience as a practitioner and also my experience talking to doctors and first responders about what happens and what should be happening. Now, when someone completes the POLST, their primary care physician signs it, they can sign it, or if they're not able to sign, their healthcare representative under advance directive is allowed to sign as well. There is a POLST registry up at OHSU, and if you don't want to become part of that registry, you actually have to opt out. It's, you know, the default is opting in. And you receive at some point a card to carry with you on your person. And so, you know, generally speaking, you know, if I go out and see my clients a lot and I see on their refrigerator, they have a, if they have one, they have their POLST form, you know, with a magnet on their refrigerator. And so when first responders come into the home, they're going to be looking for that. That's an easy one. It's a little bit more dicey when someone is out, and I always say down in the parking lot of Fred Meyer, I don't mean to cast aspersions on Fred Meyer. They're not causing heart attacks. It's just down in the community somewhere. First responders generally are trained to stabilize and transport. That's their job, and that's great. If they're going through a person's, you know, wallet or purse, trying to find out, you know, contact information, etc., and they come across this, in my experience, it's a pink, you know, small card that could fit inside a wallet, etc. They know that they can go to the OHSU registry and see what the directive is. And because, again, I'm going to say doctor, but you get the idea, because, you know, a doctor has signed it, they will honor that. unlike the advanced directive, there's no doctor in the picture. And if someone's, again, my hypothetical, down in the parking lot of Fred Meyer and, their healthcare representative is standing over them waving the advanced directive form, he doesn't want to be saved, they're going to gently move that person aside, stabilize and transport, because that's their job. And the advanced directive has no control over a first responder. So that's another important difference. Okay. Looking at my time, I'm going to go HIPAA. I've already talked a little bit about that. It can be an important document to have. In the packet, there is a HIPAA release. It is just a release. There's not one set form. If you know your clients, for example, are members of the Kaiser network, I would get the Kaiser HIPAA release, etc. You get the idea, but there is a generic HIPAA release in the packet. And that can be an issue if we need to gain access to protected information. Although I can tell you, fortunately, in my practice, I've never really had to go to court to get access to protected information. Either access was granted or we got it some way, through my documents having a HIPAA release, a generic HIPAA release, etc. All right. All right. I'm going to move over then, if there are no questions, to planning for death, the fun stuff. Who gets it? All right. And basic estate planning, we're talking about a will. And there's nothing the matter of having a will as your main estate planning document for what happens after your death. There's clients and friends, relatives talk to me about wanting to avoid probate, that court process that needs to happen when someone passes away with a probate asset. And I'll delve down into this deeper in a minute. Because they've heard horror stories about probate. And I get that, and that's fine, and I have that discussion. Well, first off, with you, in your help with legal aid, doing a trust probably is one standard deviation outside of what you probably want to be doing anyway. So wills are fine. I can also tell you that probate in Oregon is not that onerous. I do probates all the time in my practice. A lot of the horror stories you see in the newspaper or hear about actually come out of California. Probate in California is ridiculously expensive and time consuming, and I get that. Most people, if they can afford a trust in California, have a trust, and that's great, just for the purpose of avoiding probate. But probate, it is a process. There is some time. There's an attorney involvement, so there's expense. But there can be good reasons to do a probate as well, cutting off creditors' claims, etc. So I oftentimes tell my clients, I'm looking at, the most bang for the buck. If you come to me and you tell me you have real property outside of Oregon, then yes, a trust makes sense, because if we have a real, we have the house in Oregon and a cabin in Washington State, just as an example, then yeah, we're having a probate in Oregon and then an ancillary probate up in Washington State. Probate's fun, but it's not that much fun. And so then I start looking at trust as a way to avoid that. But most of my clients shake their head, no, we only have our house and we're lucky to have that. So, and my trust-o-meter is not scooting over to the got to have one end of the spectrum in that case. Also, if you're dealing with, a married couple, whatever variety, generally speaking, in that spousal situation, at the first spouse's death, we're not going to have a probate anyway, because we don't have a probate asset. So let's tease that out a little bit. A probate asset is an asset in an individual's name alone without a right of survivorship or a valid beneficiary designation. So in a spousal situation, we have possibly a jointly owned home. Certainly check the deed to see what the ownership interest is, so you can update it, but if needed. But generally, whatever the ownership is, there's a right of survivorship there, not a probate asset. Jointly owned bank accounts, there's a right of survivorship, not a probate asset. Retirement accounts, beneficiary-driven asset, life insurance, annuity. Go through with your clients to make sure they know who their beneficiaries are, or make sure they update them to meet their wishes. But a life insurance policy with a valid beneficiary designation, that is not a probate asset. So at the first spouse's death in a couple situation, we look at that will and say, well, that was good insurance, but we're not going to need it, and we set it aside. But what we're doing is then we're loading up the surviving spouse's estate, probate estate, with probate assets. That jointly owned home moves over to the surviving spouse. At some point, we'd want to record a short form death certificate in county deed records, but that can happen at any time. But they're now the sole owner of that home, and if they pass away still owning it, that's a probate asset. Real property is the most common type of probate asset. Okay, and that joint bank account, and the first spouse dies, and now it's solely in their surviving spouse's name. That's a probate asset. Okay, so then having a will versus not having a will. Having a will makes the probate process run more smoothly, and avoid unintended outcomes, because the laws of intestacy in Oregon may or may not mirror your client's wishes about who they want to get what at their death. And you need to be able to explain that to them and get their input. And also, by the way, talking about spouses, you have a potential conflict there, particularly if it's a blended family, which is not uncommon. I regularly get conflict waivers from my clients, because I don't want someone coming back and bringing a complaint against me, years from now. So I just get that, and I would recommend you do that. And if I recall, I believe there's a generic waiver in the handouts, but you may already have those. So, wills are great. One misunderstanding I've had clients have, well, if we do a will, we avoid probate. No, that's not how it works. Doing a will does not avoid probate. Again, if we have a decedent with a probate asset, we need to go through probate. The will, like I said, just makes the probate process run more smoothly. For one thing, most lawyer drafted wills waive bond for the personal representative. And a bond isn't a huge burden, but it's another hoop that we have to jump through. And based on the size of the state, we either have to restrict assets or, to reduce the bond amount, or, just bond everything. There's an expense there that we could avoid by having a will. So if we're going with wills as our main post-death estate planning document, it's better to have one than go through intestacy, which, because the state of Oregon doesn't know who the named PR is going to be, there's a bond requirement, and it just slows things down. And I've had, this is a bit extreme, and I'm ticked at myself and my client, but I had a PR that was appointed in August, and we're finally getting the bond filed today. And fortunately, it's an county, the probate is in a county that is backed up, so they haven't dinged me yet. Not to name any names, but you know, having a bond requirement is just an additional hoop to run through. So in my wills, and most attorneys drafted wills, we're waiving the bond. Again, you want to consider capacity. You know, it's the traditional, you know, you learn this in law school. They need to know who the objects of their bounty are, generally who their family members are. They need to know the nature of their assets, but not down to the penny. You know, can you tell me about your assets? Well, I have a bank account, and I have a retirement account, and I have a pension. You know, that's probably good enough. They need to know what a will does, you know, dispose of their assets at death, et cetera. And, you know, if they're able to affirmatively respond to the point that you think they have testamentary capacity, you're good to go. The testator or testatrix, you know, obviously they need to sign and date the will. Their signature does not have to be notarized. That's not part of the execution requirements in Oregon. And for my value, there's no need for their signature to be notarized. It doesn't do us any good, really, because the basic challenges, will challenges, it's not going to be dispositive anyway. The will does need to be witnessed by 2 witnesses. Those witnesses do not have to be disinterested. They can be a beneficiary under the will. They can still sign, not a problem. When I'm signing in my office, I'm not using, you know, a beneficiary, a spouse as a witness, but I can tell you, again, based on the nature of my practice, I do house calls, and then I'm, you know, trying to save money for the client, et cetera. I don't want to drag a paralegal along, et cetera. I'm oftentimes using family members or neighbors, et cetera, to act as witnesses. We're good to go. Now, it's helpful to also have the affidavit of attesting witnesses signed at the same time, so we have it all together. Does not have to happen simultaneously. We can, after death, we can get an affidavit from one of the witnesses. You know, I don't like doing that because sometimes they're hard to track down, et cetera. But so I would recommend getting the affidavit of attesting witness signed. That one does need to be notarized. You know, those witness signatures on the affidavit need to be notarized. I can tell you there's a relatively new RS 112, whatever, the harmless error statute. There are a lot of writings that are being admitted as a will now that would not have been 5 years ago. For better or for worse, I think some of the writings that have been admitted are beyond what the law, sorry, my light goes off, what the law contemplated. But I can tell you, I've spoken with a practitioner who got, you know, no witnesses, obviously no affidavit of attesting witnesses, will admitted. And I'm not sure that's what RS 112 contemplated, but I know it's happening now. You don't want to be in that situation. You just want to make sure you're going through the requirements of execution on a will. And so it never hurts to look back at the ORSs on these various documents just to make sure somebody hasn't thrown something new in there. I regularly look back at admin rules or ORSs just to make sure I'm current. And actually, just as an aside, the local court rules. I'm constantly checking those because I don't want to be caught out by a probate administrator, for example. So my advice would be to review the ORSs, et cetera, as you're going through drafting, just to make sure you haven't missed any of the requirements. Anyway, so that's basically all I'm going to say about wills and probate in general. There are will substitutes or will probate avoidance measures, which I'm going to talk about now. So the first option is to do a revocable living trust, which is great, but that's probably, as far as working with legal aid, outside the what the standard practice, I guess I'd say. But in your own practice, you might be doing trusts. Those are fine. My only caution there is to make sure, if you're doing a trust, to make sure it gets properly funded, because I review a lot of trusts. Oftentimes when clients are moving to Oregon from out of state, but that's not necessarily the case. And it's not uncommon at all to find that a trust is unfunded or is only funded with the house, because that's the easy one to get into the trust via a deed. Bank accounts, brokerage accounts, what have you, are out there not funded into the trust, or at minimum having a beneficiary designation pointing to the trust. And an unfunded trust just isn't going to do what it was intended to. One, primarily avoiding probate, because all those non-trust assets, again, if they're a probate asset, no valid beneficiary designation, no right of survivorship, we're going through probate land anyway, and then pouring it over into the trust if there's a pour over will. If, heaven forbid, the attorney drafting the trust didn't do a pour over will, so we don't have a will at all, we're looking at intestacy, and that might be vastly different from what the trustor intended. Enough said on that. Other probate avoidance. Joint ownership, I mentioned, is great. In a spousal situation, that's normal. I never recommend joint ownership when I'm having like a parent and they're saying, well, why don't I just put my daughter on the account? Yes, that would avoid probate at mom's death, but there's too much liability, too much risk. That the daughter turns out to have an addictive personality, money's gone. Or, that's not that common, but let's say the daughter gets in a car accident and is held up to be at fault, and there's a judgment against her. She's a joint owner on that account, and the judgment creditor is going to go after it. And yes, we might be able to unwind that, but the only way to do that is in court. Not a good outcome. So if one way to avoid probate, and I would still do a will in any case, because we never know what our clients are going to own on their last day on earth, would be to add a beneficiary designation to accounts. You can do that. I mean, the normal beneficiary driven assets that we spring to mind, retirement accounts, life insurance, annuities, those types of things. Again, you want to be reviewing with your client to make sure they've updated their beneficiary designations anyway. But a brokerage account, a bank account, etc., your clients can add a beneficiary designation to that. Depending on the institution, it's probably going to be either called a transfer on death designation, TOD for short, or pay on death designation, POD. But really what they need to do is make an appointment with the banker, for example, and walk into Chase or wherever they bank and meet with the banker and say, I need to add a beneficiary designation to the account. And the banker will know what's going on and, be able to pull out some forms from their drawer and help the client complete those and get them submitted and hopefully accepted before death. So at death, that hypothetical Chase savings account with $15,000 in it goes to the intended beneficiaries versus needing to go through a probate. Okay, so those types of beneficiary designation means of probate avoidance, I'm all for. But joint ownership with someone that's not a spouse, I balk at, because I will admit I see the worst of the worst. One of my partners, Brooks Cooper, is a litigator, and he's fantastic. I'm not a litigator. I go to court if I have to on my own documents, but I don't accept litigation through the door. Brooks does. And guess what happens? Comes in the door, any administrative work, he says, Darren, can you do this for me? And I'm happy to help him out. And he does the litigation and I do the administration. So I see a lot of the terrible ones you read about in the newspaper, et cetera. So I'm just not a big fan of adding a friend, a family member, a child, certainly not the caregiver, et cetera. All the horror stories you read about, I'm just not a fan of those. And I would advocate for you to try and convince your client not to take those steps either, because it can be fine. Don't get me wrong. And I understand that it's simple, but it can also be abused or be a subject of litigation if there's ever any, liability exposure out there. All right. Pausing for questions. I've got about 5 minutes left, and I'm going to jump through a lot of different things. So if you have questions, feel free. Again, the packet you're going to receive contains my outline and some other writing, and then examples of different, the will and a power of attorney advance directive in there. Okay, seeing none. Like we talked about, making sure the trust gets funded. You're all aware that Oregon ORS 130 controls trust. So if you're working in that area, you need to become very familiar with that. Tax planning, either under wills or a trust. Probably your clients from legal aid are not going to have Oregon estate transfer tax planning needs, or else they, in my mind, wouldn't qualify. But just for your own practices, you want to make sure you're aware. I'm sure you know that currently Oregon's taxing threshold is the first penny above $1 million. There are ways in a spousal situation, there are ways to avoid paying estate tax, certainly at the first spouse's death, but at least reducing estate tax exposure later on. I always caution my clients, though, that we don't want to be overzealous about avoiding Oregon estate transfer tax, because that tax, again, only kicks in at the first penny over $1 million. And it's not that bad. The first $500,000 above $1 million, so decedent with a $1.5 million estate, that $500,000 is taxed at 10%. And I'm setting aside all the off the top deductions, but so $50,000 would go to the state of Oregon versus the intended beneficiaries. And don't get me wrong, $50,000 is a lot of money, but some of the measures to avoid that tax, doing a credit shelter trust, et cetera, in a spousal situation, were, assets that go into his credit shelter trust do not receive a step up in cost basis at the surviving spouse's death. And if the surviving spouse lives another 10, 15, 20 years, there can be significant capital gain built up in the credit shelter trust. And as you all know, capital gains tax, it's an income tax. So it's, it's only based on the gain, not the total value, but it's an income tax. And because both Oregon and the feds tax it, you're looking at anywhere from 24 to 36% tax bracket. And remember, I said Oregon estate transfer tax. Yes, we're taxing 100 cents on the dollar, but it starts off at 10% and steps up very slowly to a maximum rate of 16% when marginal rate when you're in the $9 million neighborhood. So sometimes we have to decide which tax we want to pay. And generally speaking, we want to pay the lower tax rate. And, you can, if you're up on estate tax and all that fun stuff, you can advise your clients or put them in touch with a CPA or another attorney to kind of look at hypotheticals and decide what fits their assets and what fits their goals. But that's a consideration. We talked about capacity, something that always should be in the back of your mind when you're helping clients execute estate planning documents. Ownership interest. Remember, I noted that if you're working with clients, spouses, and they have a home, I always get the deed to the home from a title company. It's very simple to do. They usually turn around the request in a day, if not an hour, and just make sure that the ownership interest, that you understand what it is and that it's what the clients want. Because if come to find out, oh yeah, the house is only in one spouse's name for whatever crazy reason, probably want to put it in both names via deed, unless there's a good reason not to. Or if for some reason they took ownership, without a right of survivorship, but as tenants in common, I've seen it happen on rare occasion, but it could be intentional for that fact pattern back in the day, which might not apply now, or it could have been a mistake. Sometimes your clients, as you know, try and do things themselves and muck it up. Just, employment guarantee for attorneys, but, you want to look at that deed to make sure you understand what the ownership interest is, whether it's tenants in common or not as tenants in common but with right of survivorship, or is tenants by the entirety, which, as you know, only spouses can own. That includes a right of survivorship, but just, do a quick review on that to help your client out. It's the same as making sure you and the client are reviewing beneficiary designations when you're helping execute estate planning documents. I think, yeah, I'm saying I'm about out of time. Are there any lucky last chance at questions? If not, I'll just say, when you receive the materials, look at your notes. If you have any follow-up questions, shoot me an email. I'm happy to respond, truly. I will explain it this way. Before I went to law school, I was in education. My last teaching position was up at University of Portland. So I love doing this, naturally. And I'm also on the recipient end. When I first passed the bar and went out and practiced, I received a lot of help, and I'm just kind of paying it back now. So don't feel shy about asking me follow-up questions or asking me to kibitz. I'm happy to do that as I'm available. All right.
Thanks. I have a question.
Yes, Alan.
So if somebody says the personal representative is misusing the funds, what recourse is there?
Well, if we have a personal representative, we're into probate land already. And so the recourse is, filing with the court. Probably I would do initial petition for instruction to say, hey, looks like the PR is misusing funds. Can we get a review of that? But, they're either, if the bond is waived, it's a little dicey that's the one bad part about waiving a bond, because the bond insures against the PR's bad acts. But anyway, it's going to be a matter for the court. The beneficiary or beneficiaries that believe they're being harmed needs to understand, A, the attorney for the PR is not their attorney. And B, they need to have their own attorney and get a pleading filed with the court.
Okay,
Now, if you're talking about, abuse or misuse by an agent under a POA, my first recommendation would be to call Adult Protective Services to get them involved. They would start an investigation. Now, having said that, you know that APS doesn't have any teeth. If they have a finding of abuse, they're going to turn it over to the county to prosecute. Okay, but that would be my first step with that. Also approaching the principal, if they still have capacity, saying, look, your agent is abusing their authority, misusing funds. You might want to consider revoking that power of attorney and doing a new one. That would be an option as well, but I would always get APS involved.
so I'm confused. You said that it's already in probate. Doesn't that mean the person's dead?
Well, you said personal representative, so I thought you were talking about, yes, under a will, decedent, we have a dead person and we're in probate court. In that case, it's a matter for the court. There needs to be a pleading, bringing it to the court's attention. It can be a petition for instruction, or it could be a petition to remove the PR and appoint a successor. There's different strategies, but it's a long story short, it's a matter for the court.
What other cases could there be a personal representative?
I beg your pardon?
In what other instances could there be a personal representative?
No, the personal representative would be under a will.
Okay,
And they have to be, just because they're named in the will doesn't really mean anything until they're appointed by the court and receive their letters, testamentary or intestate letters of administration. Then they're truly the personal representative. But
Okay.
if there's a report of a PR abusing funds, the court's going to want to know about that.
okay. All right,
All
thank
right.
you.
All right. Thank you, everyone.